Yesterday, I read a recent decision of the Supreme Court, and I thought of sharing certain thoughts here. I won't talk for too long, it is quite brief. And the main question is, can you really differentiate in black and white procedure from the end result? Even in the context of a criminal trial, can you do so? Can you put the procedure of a criminal trial in one compartment and the end result uh, into an entirely different compartment? I don't think so. I think that is incorrect. The end result is linked to the procedure followed. It may well be that some procedures of a criminal trial have a material impact, and some procedures may not have a material impact on the end result. Now, the end result in a criminal trial is always facing uh, the threat of penal punishment. Now, there is a provision in the Indian Constitution, Clause 1 of Article 20 to be exact, which says something elementary, uh, which is that if we have done an act in a point of time, and if that act was not a criminal offense at that point of time, the law cannot be changed subsequently and make that act punishable. Now, this case, this CBI versus R.R. Kishore case, judgment was given by a five-judge bench. And the relevant facts were that a government officer was charged by CBI. The proceedings began. CBI is governed by Delhi Police Special Establishment Act. One of the provisions of this act required that in respect with officers of a certain level and above, permission was required to be taken by CBI before proceedings could be commenced. This permission had not been taken by CBI before commencing the proceedings. The matter is the Delhi High Court, and Delhi High Court ruled that taking the permission was mandatory, and since that had not been taken, the trial would not be maintainable. Subsequent to this, in 2014, in Subramanian Swamy case, a five-judge bench of the Supreme Court held that the provision requiring permission to be taken was not valid and struck it down. Thereafter, CBI approached the Supreme Court saying that once that provision had been struck down, that provision requiring permission to be taken before commencing proceedings, it would mean that at the time when the trial had commenced, the provision would not be held to exist, and therefore the trial had been valid. In short, they argued that this requirement of taking permission when it was struck down subsequently, still it would go back in time and operate. The Supreme Court agreed, and it agreed by taking this stand, and of course relying on past decisions in doing so, that being simply a matter of procedure, it can go back in time. If it was a matter of penal punishment, change in punishment, or making something punishable subsequently, then that cannot go back in time. I personally submit with utmost respect that this kind of reasoning is far too simplistic and does not hold. Uh, the procedures of a criminal trial are linked, definitely related to the penal punishment that may result out of it. And some procedures have a vital bearing on the penal punishment linked to such procedures, while some other procedures may not be all that important for the penal uh, punishment as the end result of the trial. The correct test, I think, should have been if the procedure in question does not have a material bearing on the end result of facing penal punishment, then it can go back in time. But if it has a material bearing on the end result of penal punishment, then it would not go back in time, it would operate only in future. I don't think the matter of dispensing justice can be put in black and white. The procedural part cannot be totally differentiated in black and white from the end result, and dispensing justice is a matter of both objectivity as well as some necessary subjectivity. Provided that subjectivity is exercised within the coordinates of or within the perimeters of relevant or required criteria, and that is taking into account relevant factors, not doing something highly unreasonable, but doing something by and large reasonable which does not appear unacceptable on the face of it, etc., etc. So, to determine whether certain procedural parts would have a material bearing on the end result of facing penal punishment, or whether some procedural parts would not have a material bearing and therefore can go back in the past, is a matter of subjectivity which cannot be removed from the task of dispensing justice. I hope I made some sense. Thank you.